Hi, everyone. Thank you for joining us. Today's session is going to be on practical tips on using AI ethically and effectively, which is a topic that I'm sure you're all familiar with. It's very big at the moment, so there's lots for us to discuss and some opportunities for questions as well. So before we jump into the session today, we just wanted to go through a couple of housekeeping matters. So one, you'll receive the recording and slides at the end of the session if you want to refer back to anything I've said. You can submit questions in the Q&A box and I'll get to them at the end. And there's also a survey at the end of the webinar, which would be great if you could complete as well. Another thing that's important to note is that if anything today raises any questions for you, if you'd like to discuss this further, you can book in a call with our enterprise team and they'll be able to discuss any specific legal questions you have, and also just if there's any way we can reduce your overall workload. So if you're interested in that, leave your contact details at the end of the survey as well. Okay, so getting to the agenda for today, and you will have seen a poll question pop up as well, which is related to this. So the things we're going to go through today are the common pitfalls and the key ethical considerations. And we consider this from the perspective of lawyers who have a legal professional obligation to make ethical choices in how we deliver our work. And also it's important for non-lawyers to understand some of the ethics as well. We'll also be talking about privacy law considerations and intellectual property considerations, which is some of the areas that are most heavily regulated and that AI interacts with. We'll also be talking about training model risks. If your business is training your own AI models, or if you're trying to better understand how AI works generally for using somebody else's. And then we'll go through some key tips and takeaways. So the poll question is similar to all of these. We just want to get a sense of what you're most interested in knowing about and understanding, and we can hopefully address most of that today, or if not, afterwards for you. And here's just another overflow of the key objectives. Okay, so jumping right into the common pitfalls. And I suppose we should probably start with an overall introduction into AI and ethics. And I'm sure you're all pretty familiar with using AI tools, with having people in your businesses use AI tools. There are so many different offerings now. There are so many opportunities to implement AI into your workflows. And for the most part, the law is still playing catch up, but it's not an entirely lawless space. So there are legal principles that we can apply to it. And whether you're using it on a personal level or your business is using it on a professional level, we can apply those concepts to it. And it's also crucial to note that being responsible about AI use goes beyond just legal compliance. And so we'll talk about how to be compliant legally, but it also addresses ethical compliance, which isn't necessarily mandated by law, but which is something that we should all be considerate of. And part of this ethical consideration will be having a look at the key ethical duties from the solicitor conduct rules, which are on the right there. And we can have a look at some of the common pitfalls that we'll go through. There are, as you're probably very well aware, many ethical duties that apply to solicitors, but these are the key ones that I think really are captured by AI use. Okay, so we have the common pitfalls. You probably have seen a lot of these in your own, in engaging with the media, engaging with AI yourself, or in the workplace. But a lot of them come down to these. Number one is an over-reliance on AI without human oversight. This is really common. It's common sense, really, but often we have these high-profile examples of people using too much reliance on AI without really having the knowledge of a human in it. So one of the most prominent examples of this was there is a Melbourne lawyer recently who submitted in the submissions to the court a case that was completely fabricated because they'd used AI. There was a citation that didn't exist. And this was an example of just an over-reliance, trusting the machinery when a human checking it themselves never would have made that mistake. So this is one key example of it. There's many in our workplaces. There's also the common pitfall is ignoring potential bias. And this is a really common one when we're considering how these models have been trained. The underlying algorithms, the history that they've been built off can create outputs that create things that maybe we wouldn't have come to ourselves from a human perspective. So that's a really important one as well, a key pitfall. Another is lack of transparency. We have a legal duty and an ethical duty to be clear about when we're actually using AI in our workplaces or in our businesses. And that lack of transparency can get you in trouble from a legal and an ethical perspective. Another common pitfall is having insufficient privacy practices and insufficient security. So not having sufficient protection measures to protect from data breaches or to make sure that client or customer information isn't being used incorrectly. And that also combines with poor data governance. So that's a common pitfall where people just don't really know, well, how is my business using AI? What is going into these documents and how is it being used? And so considering these common pitfalls compared to the key ethical duties that solicitors have, and these apply to non-lawyers as well, as I mentioned, there are, these are the key ones that probably relate to this. So there's a duty to the court and to the administration of justice. So that example of someone putting in a completely false citation is clearly a breach of that. We also have a duty to have professional independence and judgment. So it's a requirement for lawyers to have that human oversight, to think critically, to not have that over-reliance. One of the ethical duties is also just to comply with the law. And this one seems obvious, but I think when we dig into some of the examples, you'll see that sometimes it's easy to say, well, technically this is the law, but is there any chance this will ever be enforced? And I think it's really important that we understand, approaching this from an ethical perspective, that our duty is to always comply with the law, even if it seems like a minor breach. Another important one is that we actually have a duty to deliver legal services competently and diligently, and to not, the last one there on that list as well, to not diminish the public confidence in the administration of justice. It's a bit, don't make a fool of the profession, don't make a fool of yourself. That's a requirement. So a lot of these blunders can, especially the high profile ones, can jeopardize that. So it's an important one to keep in mind. And also another one is just to act in the best interests of the client. And when we're talking about in-house operations where your client is the business that you work for, acting in their best interests is protecting them from, reputational damage, fines at a high level, or just other misuse that might be problematic or embarrassing to them, really. So these are the key pitfalls, but we're going to dig into a little bit more some of these concepts as well today. Now, before we jump into privacy law considerations, which is up next, one thing I do want to spend a bit of time on is this concept that the more ethical, we have a higher chance of making ethical choices about our use of AI if we can understand the technology behind artificial intelligence. And throughout this presentation, and most people talking about this subject will use the term artificial intelligence, but it's really important to understand that there is nothing intelligent about the algorithms that we call artificial intelligence, and it's probably more fair to call them large language models. And I say that meaning they're incapable of independent logic or reasoning. And, they're obviously an incredibly powerful tool that has been fed from training that makes the sort of source of knowledge they can pull from really powerful and more powerful than most humans. But it isn't actually capable of that independent logic decision-making. It can only really reproduce others' logic and decision-making that has been fed. And I think understanding that really helps understand the pitfalls of how we can go wrong with using AI. So I will use that language all throughout this presentation, but that language is with the understanding that it's not really intelligent. It just seems really intelligent. Okay, so jumping into privacy, there's a complicated graph here, but this is something that I actually developed to help me with understanding some recent OAIC guidance that came out. And so the OAIC recently published some guidance on how personal information, sensitive information should be used when we're considering artificial intelligence. And the principles that the OAIC gave us are not novel in any way. Some people refer to this as like, oh, there's been a change in the law and how the regulator has told us how to use AI. And that's not the case. These principles have been in the Privacy Act for a long time, but they've just been applied freshly to this new technology. So that's an important distinction to make. But I'll go through some of the sort of flow of how this guidance works, because it's really important when we're considering on an individual level and a business professional level, can I input this information into artificial intelligence? So the number one distinction that we need to make when we're considering should this information go in artificial intelligence is it general information or is it personal information? And so most of you are probably familiar with what makes something personal information, but it's essentially any details that can be used to make someone contactable or identifiable again. So it's essentially name, contact information, similar features like that. If the information is general, then it doesn't attract any of these obligations. If it's personal, then we need to start going through some of these flows. So the most important thing probably here is APP6. And it's the principle that is summarized here. And it's all about the primary purpose. So APP6 essentially says, you're only a business, a person, anybody, when they receive personal information from someone, you're only entitled to use that personal information for the primary purpose for which it was collected. And any secondary use needs to either be with the individual's consent or it would be reasonably expected that you would use it for that. And so this is really the guiding principle for all AI use is, has the person given me this information for this reason? And would they reasonably expect that I'm using it for this? If not, I probably need to get consent. And in addition to all of this, a lot of this can be addressed by sort of having robust other privacy documentation. If you've got clear terms of conduct, terms of use for the service, privacy policies and collection notices, that makes this assessment a little bit easier in terms of saying, I've given these people all this information that says we use AI in the course of providing our services to them. So would they reasonably expect that in providing the service to them ultimately that we are using AI? Yes, we've given them all these reasons to believe that we are. We've told them we are. And so they're entitled to do, so we're entitled to do that. One area where it gets a little bit more tricky is with sensitive information or health information. And so sensitive information is, of course, things like that sensitive information is essentially, it just has that higher protection. It's the category of information that someone might be a little bit more protective over, like religion, ethnicity, health information. There's a number of things that fall into that, as I'm sure most of you know. And essentially, the OAIC has said their guidance, and APRA has also echoed this, is that for sensitive or health information, you really should be getting consent every time you're inserting it into an AI model. So this is a really important thing for businesses to understand. A lot of businesses won't interact with this type of information in the way that they're using AI, but some of them will. And so it's important to understand that. Another really important thing to consider from a privacy perspective is automated decision-making. And so this is something that has come out of recent reforms with the Privacy Act. And as some of you may be aware, there's been 3 tranches of reforms, or there's likely going to be 3 tranches of reforms in the privacy space. We've had the first come through late last year. And so one of the amendments that came through with that was that where if your business is using AI to make automated decisions about someone, you just need to be very transparent about it. And some other jurisdictions like the GDPR are even stricter about it, and you have to give people the option to opt out. But for the moment, Australia just requires transparency. But there's a couple of case studies here that I want to talk about that are an example of why this can be so precarious, and particularly from a privacy perspective as well. So the first one is an Amazon recruitment tool. And this was, I think it was in about 2016, but the whistleblowers essentially discovered that Amazon was using a tool to review resumes for people that applied for a role with them. And because of the way that the algorithm had been set up, it was devaluing or downvoting essentially resumes from women, because it had, well, I can talk a bit later when I get to the training models why it was doing that. And it's importantly, none of these case studies about how training models have created these errors were intentional. None of the biases were intentional, but they just happened to be the case. So in this instance, there was no human oversight. That was one of the number one pitfalls we talked about at the beginning. There was no human oversight to say, well, hang on a minute, every single candidate here that's been progressed for an interview is a man. Why is that? So that's something where an automated decision-making tool has the opportunity to really make real-life consequences and affect individuals, but it should really always have human oversight. Another one is Compass, which was a US service that was essentially used to calculate the likelihood of young offenders re-offending. And there's a similar theme with a lot of these, but it made a very similar error in that it over categorized Black Americans for reoffending, and it categorized them that they were much more likely to. And again, it was based on training model that had created this error and this bias, but it was actually used for helping judges decide on sentencing for these offenders. And so it had very real consequences, but it didn't have the requisite human oversight for someone to go, well, actually, do the rest of the factors mean that this person is likely to reoffend? Why have we come to this conclusion? So it can be very precarious from that aspect as well. And then the third example was another high-profile one. All of these received a lot of media attention at the time. This one was the UK government used a tool during COVID to help assess school students that were too unwell to take their A-level exams because they had the virus. So they needed a way to essentially be able to estimate what these people would have, the likely results they would have gotten. And it incorrectly gave value to people that had gone to private schools versus some of the lower socioeconomic environments. So people that are in certain suburbs were getting much higher estimated marks than those in different areas, which again, with all of these examples, as soon as a human reviewed the data, they came to a different conclusion at most of the time here. And the teachers, there was an examination where teachers sort of blindly assessed these things. And said, what would you give this student had this not been the assessment made? And that's how they sort of discovered that this was completely wrong. So from a privacy perspective, we need to make sure that we're being really transparent about how that's being used and just being really cautious about it. Have we set these up in a way that's likely to create problems from an ethical perspective? And, you know, with a lot of these, it's talking about that diminishing public confidence, one of those requirements that is in the solicitor's conduct rules. Okay, now onto intellectual property considerations. This is another one that I think we got some questions about before the session, and it's a really common field that people are confused about, so it's important to understand. And essentially, there's two sides that I want to talk about today. Number one will be the ownership piece, and then the second part will be the infringement piece. So starting off with ownership, there is this question of who owns the output from AI, who owns it. Is it the user who has been prompting it? Is it the provider, like as in ChatGPT or Claude or any of the other Genesis Google providers? Is it anyone? Is anyone capable of owning it? And is anyone capable of having protection over it? So it's not clearly yet settled in Australian law, but we can draw on some principles that have been around for a really long time and have been applied to this. So essentially, there is a concept in Australian law that to be capable of intellectual property protection, something must have a human author. It must have originally come from a human. And with artificial intelligence, we have this problem of, well, is that ever the case? And some people argue that the way that humans have trained the back-end models of AI means that there is probably some human contribution. And some people argue that the way that the user will encourage and prompt and change the output will also potentially provide the requisite human authorship requirement. But for the most part, the law is pretty steadfast in saying, no, that isn't sufficient. And until we get further guidance, which we do think will come, if your business is putting important, valuable assets or trying to generate important assets with AI, I would really caution against using it, because there is this risk that it will be invalid, or at the very least incapable of protection. So, for everyday operations like, writing a customer email or, marketing content, it's probably lower risk because, are you really going to try and register and enforce those things? Probably not. But if, for example, there's people in your business who are using it to help code, problematic potentially if you're then trying to claim copyright over that code. And then we can get to it. There are some potential issues with potential infringement when we're using that as well. And the other side of this as well is that the AI, generally a lot of the AI providers have drafted their terms of service to say that the user is the owner, and it gives the provider a license to use some of it as well for their own sort of training, internal purposes. So from a contractual perspective, that's what it presents to be. But ultimately, we know that we still have this conundrum here with the human requirement. And another issue is also originality and whether or not it actually hits that mark. So, we need to make, often the threshold for copyright patents and designs is that there's got to be a certain level of innovative, novel aspect to what we're creating. And when we're using heavily AI to do that, there's a risk that we're not actually doing that, because it will always be giving us answers that have come from a training model that is somebody's other sources. And so when it is giving us answers that have come from other sources, those sources already exist. So are we really creating something novel when clearly it's come from something that's already been in the public sphere? And so that leads me on to the infringement side of the piece. And for the most part, this is inadvertent infringement that we're talking about here. So because of the way that we know AI is created, in that it is built off all of these hundreds and thousands, sometimes millions of sources, we don't often know where those sources have come from. And so in many instances, it's, scraping publicly available articles, reports, websites, where someone originally at some point wrote that work or created that work. And so that someone will have ownership rights in the original work. But when, I'm asking AI to help me prepare something new, I can't really see as a user where that original source has come from. And it's highly likely, and we know in practice it is definitely happening, there are like word for word reproductions of someone else's work being spat out by AI, which if we were to publish, to make public, is technically infringement. And so we do have to be really cautious about this if we're trying to create, again, and it comes down to, well, what is the thing that we're ultimately creating here? Is it something lower risk, or is it something that is really important to the business and that we do want to have ownership over? Is it a manual? Is it a report? Is it something that we want to have the copyright in, but we've relied on AI, which means technically we could have unknowingly infringed from somebody else. So that's a really important thing to know. A lot of people say, well, how can I possibly know? And also, how can the party that's been infringed possibly know? So am I ever going to get in trouble? Is this ever going to come to fruition? And this is one of the areas where I think we need to remember, from an ethical perspective, solicitors' conduct rules tell us that we have an ethical duty to comply with the law. And so if we're taking a strict letter of the law approach, then we need to be really cautious about this, because it is technically illegal. I do think we will likely see some amendments in this space from case law, maybe potentially not statute, but likely case law, in how we can use some of these concepts as we, advance along with the technology. But for the moment, we do need to have, it is a pretty conservative approach that we're taking. Okay, now moving on to training model risks. So some of your business may be doing creating its own large language model and maybe training it itself, or most businesses are using somebody else's. But there are some risks to be aware of. So the number one is data scraping. So this is technically not illegal in Australia, but there are some aspects of it that can be a bit treacherous here. And then for anyone that's unaware, data scraping is essentially the process of taking, scraping publicly available sources, as in, copying word for word publicly available sources and putting it into this AI generation, back-end training models. And so it's really common for people to do it when they're trying to create large data sets, if they just have a sweep of the internet to see what are all of the information about this topic and then combine it into one. So that in and of itself isn't illegal. However, as you may have figured out from the slides here, if you're copying it word for word, that's copyright infringement. And so we need to be really cautious that we're not doing that in training our models, and we're not engaging in infringement when we're training our models. We also have the risk that the information we're scraping contains personal information, which would be a breach of our privacy obligations if we're not complying with APP6. So if that person has put, and so APP6 again is that requirement that says that we must be using a person's information consistent with the primary purpose for which they've given it to us. So if this person has put it on their website to say, contact me about, anything and everything, and then we've scraped it, it's probably less high risk because they're open to being used for, anything and everything. But if we're, using something like an email signature that has someone's email or contact information on it, and we're using it to train AI or create lead generation, that is probably not consistent with the Privacy Act. And with the penalties that we know the OAIC has the right to enforce, it is really high risk. It can be, millions of dollars in penalties if we're not doing that correctly. So that's something to be really cautious of. Another thing to be really cautious of is using customer and client data. So oftentimes, and this is considering this separate from personal information and the privacy consideration, this might be, say, analytics from how they've used your service. Are we then trying to put that into the back end of training? And essentially, there is a risk there that we're breaching our contractual obligations to our clients. So often, many of the service agreements have a clause that says that that information is owned by them, that data is owned by somebody else, or simply just puts restrictions on how it can be used. So in these instances, for the most part, as long as the documentation across the board reflects the actual use, you can do a lot of this. If we're saying in our services agreements, we're going to keep the anonymized data and we're going to use it for this reason, then you are permitted to do it. But it's something that we see in practice a lot of businesses don't consider until they're already doing it. So it's really important to make sure we've got that right. And you might be thinking, well, what if I just de-identify all of the data? What if I get rid of all the names, all of the emails, all of the phone numbers? Can I use that as a training model? And the short answer is yes. But the longer answer is we still need to be cautious with this. And because we have this issue where what we consider de-identification as this technology progresses, we've seen that actually it isn't often sufficient enough. So for example, if say there's a 42-year-old man with a rare medical condition living in a small town, he could be, and we take all of the information away from who he actually is, but we keep those features, that person can very easily be re-identified by a couple of those features alone. So some of the approach that we see in practice is businesses doing a replacement method where, if we're saying it's a 42-year-old man, we change it to a woman. We say it's a small town in X, we say it's a small town in Y instead. So it's a step beyond de-identification. And for the most part, this is really only likely to be necessary when we're talking about health or very sensitive information, but it's something to be cautious of again. And then considering as well the training model risks with those case studies that we were talking about earlier. Each of those errors and the automated decision-making problems, they came from training models that weren't really sufficient. So the Amazon example where there was a recruitment tool that was used incorrectly. So the problem with that one was that it had been trained on all of this information from the actual successful candidates in the past, who had all just happened to be male because of the way that the industry was. And so without ever having fed it that information, it was valuing higher the resumes and information of men. And it's the same really with the other two examples. The US reoffenders one, it was the same, where it had just been fed information about the individuals that were likely to reoffend, and some of them happened to be from certain areas, certain backgrounds. And so it created a pattern where everyone from that area and everyone from that background was likely to have the same result, which was the same with the UK case. So it's really important to make sure we've got this right from a bias perspective, so that we're making sure that we're not exposing our businesses to unnecessary risk, and we're not exposing them to these ethical pitfalls either. And I think if we're considering from an ethical perspective training model risks, another thing that is really important to mention is the environmental impact of doing this. So that includes when we're training large language models, the environmental impact of that can be enormous. One large language model, the University of Massachusetts has recently said that it's likely that it will take the equivalent energy output of about 125 round trips between New York and Beijing. So it's really significant, something to be aware of. Okay, so wrapping up here, what can we be doing to make sure that we are protecting our businesses? And one important thing to remember is that ultimately our businesses will always remain accountable, and the individuals will remain accountable for AI outputs and decisions. It's not a defense to ethical or legal breaches to say the AI did it, we didn't do it. So we need to make sure that we're using it just like any other tool to make sure that we're not engaging in any of the examples that we talked about before that are likely to get us into trouble. And so for some of the key risk management strategies, and we've touched on a couple of these so far, and this is really what we do in practice with a lot of our clients to make sure that they're being compliant here, is making sure we've got robust testing and verification processes, maintaining human oversight always, making sure that the contractual clauses in our agreements protect us as much as possible from liability, making sure that we're being transparent about the use of AI, making sure we have policies to show exactly how we use it and the steps that we're taking to make sure that it's safe and secure. And then keeping good records and just file notes to make sure that, if a regulator does come knocking saying, what's gone on here, we can show that we've been taking it seriously this whole time. And another thing that's really important is just to stay on top of changes. And even, attending a webinar like this is a way to do that. So that's the key strategies. And this is just an example of a likely policy that we create sometimes, which can help clients and be internally mindful of this and also externally. Okay. So that concludes the main part of the webinar. Hopefully you found that useful, and thank you for all contributing to that poll question. I can see a lot of the information has come through now. It seems like the majority of you are interested in understanding privacy law considerations. So I hope we've been able to helpfully touch on those for you. And then the second most inquired about category was it was a bit of both, actually. We've got a tie. Liability for AI-generated outputs and intellectual property risks. So hopefully you were able to get some insights into that, but we can always, if you have more questions, feel free to ask them now, or you can get in touch with the survey at the end. Now, I did just want to take a moment to mention this free download, which is really helpful. This is, like I mentioned before, we've had the first tranche of privacy reforms come through, and this is essentially an info sheet on the key ones to be aware of. So that's really helpful. And we'd also love to have you at our next webinar if you're interested. It's about winning retail lease disputes, strategies for landlords and tenants. And that's next Thursday, the 10th of April at 11 a.m. And we also want to take a moment to talk about our desk extension model, which is how a lot of us, how we really support clients with these issues. And essentially, a model, having spoken to hundreds of C-suite and in-house counsel, we've found that lawyers are increasingly being pulled in lots of different directions. They are required to provide business critical, strategic, executive support and to the rest of their team, and on a tight budget. And so under desk extension, we essentially are able to assist the business with your business as usual needs and allow you to cost effectively increase the bench depth and capability of your team to prioritize those business critical matters. So if you're interested in that, feel free to pop in your details at the end of this session. Okay, so just having a look at a couple of the questions that have been submitted, and feel free to keep submitting them now. There were some that were submitted at the beginning as well that I'll be able to get to. So the first question is, does AI get around plagiarism and copyright? Well, hopefully I've answered that a little bit for you already. I know that one came in at the very beginning. In a sense, essentially, no. And this is where one of the key principles that I was talking about comes into effect, that ultimately, we or our businesses are always going to be held liable for the output and the input of artificial intelligence. So simply by saying, this was generated by AI does not get us around them. And when we're considering, copyright, that's where we really need to consider, where is the source of this come from? Have I inadvertently infringed something else, potentially? And ultimately, sort of the key takeaway really is, if you're intending to create something, if it's likely to be high value, if you really want to make sure you have protection of it, the best thing to do is to keep it away from AI and to develop it solely by humans, and considering all of the novel inventiveness requirements that often go into that. Another question that we've had is, how do we best guide employees to use AI in the workspace? And I think this is one we hear a lot from in-house counsel. I think a lot of the time people almost don't want to know what their businesses are doing because it's hard to have oversight of it. In practice, we've sort of discovered that having a policy of you're not allowed to use it doesn't work. People just do anyway. And so our preferred approach is to encourage people how to use it safely. And so oftentimes that means using a business supported model rather than having everyone use their own potentially unsafe or unsecure provider. Have a provider that the business is confident in, and have a policy about how it can be used. If your business is likely to bring one on, you can close the loop, close the circuit, so that it's not feeding back out training information that the model can be used to train off, which is just going to expose your business to a lot less risk. So I think the short answer to that one is embracing it with an understanding that people are going to be using it, and giving them the tools to use it safely in a way that will expose your business to the least amount of risk is really how we recommend guiding employees in the workplace to it. And we provide we do a lot of drafting of internal policies that are able to be used for that as well. Okay, we've got another question saying, what are the requirements with call recording and AI tools? So that is an interesting one. That comes down to the Surveillance Act, which isn't something that I've talked about today, but it sort of interacts a little bit with the Privacy Act. And in essence, the principles, and it's technically different in every state in Australia, but they're all very, very similar, is make sure that you have just told someone at the beginning of the call. So you may have been on calls in business already where you've seen that, but you just need to get consent, and you need to get consent every time and give people the opportunity to withdraw consent. So that usually just looks like, and it can be informal, just saying, do you mind if I record this call? Some businesses, as you might know, just calling Telstra or something, they'll have a recorded, we are going to record this call, and that's the more formal version of that. But essentially, you are entitled to use call recording and AI tools to summarize that recording or create file notes. You just have to be transparent about it, is what the law says. Okay, we just had another one come through saying, do you have any views on using synthetic data instead of de-identified data set in training, say, healthcare models? Yeah, absolutely. And so I touched on that a little bit. Synthetic data, I think, is a really great way to make sure that there's basically no risk of breaching privacy obligations, and making sure that we're being really cautious of any risk of a breach. What I would say is it does potentially open up the risk of bias or inaccurate results. And I say that because if we're relying on those data sets to provide insights into health from a diagnostic or treatment perspective, is it going to be drawing conclusions that are inaccurate because we've given it almost a creative, not quite true approach? So that creates that risk from that perspective. And it's probably a risk that can be mitigated by having a specific use for that synthetic data, but I wouldn't be using it to help, diagnostically, or to help train other models for if other people are going to be asking it questions based on those data sets, because it just has that inherent risk of being inaccurate. But it is a really great tool to avoid privacy risks. So we see it a lot, and in some ways it's been encouraged by regulators. So there's nothing wrong with that. Okay, another question. What sort of details should be included in website privacy policies, bearing in mind? Yes, so your privacy policy should absolutely be setting out how you use AI, how your business uses AI. And this is where it all comes down to that. Once again, I won't stop yapping on about it, APP6. So if, it's built into your business's service offering that you're going to be using AI, in any step of it, it should really be set out in the privacy policy. Sometimes it should also be in the collection notice. And so that's the document or the pop-up that'll happen usually when a customer, a client, an end user initially gives you their contact information or their personal information. And there's an opportunity there as well to say, this will be used for AI. But essentially the takeaway is transparency is key and disclosure is paramount. So definitely make sure your privacy documentation is updated to include the likely usage that will be happening in the business, and to make sure beyond that, that usage is consistent with the primary purpose for how that person has given you that information. Okay, so I think that's all of the questions we have for now. There were a couple of other questions submitted at the beginning that I think I got to during the session, so hopefully I answered them there. But if you have any other questions, feel free to reach out. Hopefully that was helpful for you all. And yeah, stick around to provide that survey at the end as well. That'd be fantastic. Thanks a lot.